I assume that's your witness. Are we ready to let him in?
I'm sorry, I forgot that, at this point.
Are we ready to let him in?
Yes.
Okay, just making
Thank
sure.
you, Ms. Barabbas.
I think he disconnected.
Do you want to try to text him?
Yes.
He's joining again.
Right. Blood pressure can come back down there.
Mr. Howery, can you hear me?
I can.
Okay, welcome back. Thank you for making time today to continue your testimony. Remind you, you remain under oath. Please proceed. I'm sorry.
I understand.
Thank you. Please proceed, Mr. McDougall.
Thank you very much, Mr. Hirsch. Mr. Howery, I believe that yesterday when we knocked off, we were talking about how the responsibilities of the agency CISA, what their interface is with the Department of Justice in terms of information infrastructure security. Can you describe that?
So the primary role across the federal government is to set and work with standards. I mean, they've taken over maintenance of the NIST protection profiles. And they also, advise the other agencies that are independent, obviously, of DHS, but they advise agencies as to how to comply with, security protocols and requirements, essentially. The agencies still have a large amount of discretion with regard to the implementation of FISMA, but they do put out advisories. They also connect with, DOJ resources such as the FBI concerning, risk mitigation, risk identification, these types of things.
All right, sir. And how do computerized voting systems fit into the FISMA, CISA structure, regulatory and law enforcement structure we've been talking about?
So they've been formally declared to be part of the critical national infrastructure, which brings them under some level of heightened security requirements. You have kind of a double overlay with, EAC and CISA with regard to, certification of these machines. The certification processes are governed under, HAVA. And so the HAVA certification processes fall under federal law because they're HAVA, federal election law, we call it, but the civil rights law with regard to the conduct of elections known as HAVA.
All right, sir. And you made reference in your
Gesundheit.
question. You made reference in your earlier testimony to the a risk management framework analysis for critical infrastructure, and give us a elevator version of what that means.
So the risk management framework is the process by which you manage and mitigate risk. And so part of that process, the starting part of the process really is something that's called the risk assessment. So as you work through the system, the basic process, it's called a spiral. It's an iterative process trying to improve the risk management of any critical system, over a period of time. But the first thing you do is identify the risks. The second thing you do is you select possible mechanisms of mitigating the identified risks. Once you've got a design, you build a program to implement the containment of the risks with the security protocols, or what's called in the cybersecurity world, your controls. And then you do an assessment, an ongoing assessment. You start with an identification of the risk, but then you assess whether or not the system itself is addressing the critical risks that were identified. Then you have an authorization step. It's called an authorization step, but actually it's a decision step as to whether to authorize the design to go forward or not. And if you do it, you are duty bound to have in the controls risk assessment ability to monitor whether or not things are being done or used or handled the way that they're supposed to. So there's an obligation under FISMA and actually under CISA guidance with regard to election systems to have monitors. You may have heard the word Albert monitors before. This is a process by which they're currently trying to monitor the effectiveness of their cyber protections. But understand it's not just cyber. It includes the operational security profile of a particular application.
Okay. And I think earlier you were talking about cybersecurity as distinguished from operational and procedural security. Did I get that right?
And so the risk management framework includes a assessment of the risks of using particular devices in a particular operational context. It would be nonsensical to do otherwise, right? So if you're using a car, you're going to use it like a car is used. If you're using a rocket ship, you're going to use it like a rocket ship is used. So a risk management framework analyzes the risks associated with particular systems and devices in a particular use context. There is no sense of risk if you don't know what the use context is. So the two are not independent. And so you also build controls. They're operational controls that define what the training requirements are, what the use requirements are, whether people are led into secure areas or not. These are all part of the operational risk profile. Generally speaking, in the industry, we call it the operational security boundaries, and there's many of them. It's not just one example that's been discussed a lot with the machines is the decision about whether or not you can connect them to the internet and what that even means. But the other ones are quite simple. Are the machines supposed to be locked up at night? Do they have, single root passwords, or do they have multi-layered passwords that control what privileges people that have the passwords can implement on the system? And so the operational security profile needs to take all of those basic design parameters in place. As I've said before, the most insecure device in the world can be used securely in a proper context. And the most secure device in the world can be used insecurely in the wrong operational context. So you have to, and certainly CISA is aware of this. But FISMA, the federal standard for deciding what the risk management framework is supposed to do, analyzes whether or not the risks associated with the machines, the software, and so on are well defined and well controlled with the operational profile for the use.
All right, sir. And you mentioned an Albert device or Albert. What is the Albert?
They're called Albert sensors. They're just a mechanism by which the DHS and CISA can monitor election equipment and certain types of risks. They don't cover all risks. They just cover certain type of cyber risks.
All right. Are these RMF or risk management framework analysis requirements applicable to computerized election systems in the 20?
Yes, absolutely they are. The certification is a federal certification, making it a federal system.
All
The
right.
jurisdiction over it is federal law. I'm not rendering a legal opinion. This, would have to be determined by others. But the fact of the matter is, nobody would ever dream of doing a federal certification that didn't comply with federal law.
All right, sir. Are you familiar with the term or the concept of a risk limiting audit in the election context?
Yes, absolutely.
Can you describe for the committee the difference between a risk limiting audit and a risk management framework analysis in terms of, protecting the integrity of the election?
So risk limiting audits are focused on basically three components of the election, and there are things that are done after the fact. The operational security boundaries are things that are supposed to be done, first of all, done before the fact. The training, the procedures, the policy, the things that are supposed to be done. All the risk limiting audits do is look at whether or not the counts and the registration of precinct tickets and the ballots with regard to a limited set of vectors of potential attack seem to be accurate, but they don't look at it holistically. The risk management framework would certainly include those risk limiting audit ideas. It wouldn't exclude them. They're completely compatible, but the risk limiting audits are extremely small portion of what's required to determine whether or not a system is secure in a particular use context. It's also much less than what's required under the law. The auditability requirement in HAVA basically says all auditable items. So the implication of the wording from a plain, and remember, this is embedded in not just the law, but in the system standards guidelines that are supposed to be used by non-lawyers. So the guidance is all auditable items are supposed to be maintained for 22 months after the election. And that means, it implies several things to a practitioner in the security business. It means if it is auditable, and it would lend to the auditability of operational controls and FSMA, it's supposed to be maintained. So auditable items is an affirmative requirement, not a passive definition of something that coincidentally happens to be auditable. So the destruction of auditable items is against the idea or the concept of the risk limiting framework or the risk management framework.
All right, sir. Can you tell us if the Dominion voting system used in Georgia in the 2020 election had been subjected to the risk management framework analysis?
It is possible that such an analysis was sealed, but all attempts to get such an analysis ended up with there was no such document. So the researchers that I trust on this matter and my own people trying to get the risk assessment, which was done in 2020, by the way, it came up blank. There was no affirmative response that a risk management framework risk assessment had ever been done. And I trust that it hasn't been. Somebody would have defended their position if it had been. I think it's obvious that there wasn't any such thing done.
If an election is conducted in a manner that does not comply with the legal and procedural requirements that we have been discussing, is the election validly conducted under those standards?
No, it means simply that there's been a breach. So whenever you have something in the operational context that's defined in the law that affects the way that things are supposed to be done, it means that there's a breach. And then I mentioned yesterday, there should be an investigation and an attempt to cure the breach. And obviously, I'm not saying that a valid election or a non-valid election determines that Joe Biden won or Donald Trump won the election. What it means is that the election wasn't conducted according to the law. The curing process and the investigation has to determine whether or not there's a material concern associated with the size of the breach. Everybody's encountered this when AT&T or MasterCard is hacked and they send out their notes that there's been a breach, but they don't know if anything's been done. This is a notification of a total breach. And then they expect you to report that if there's something wrong, and then they want you to get into a special, credit score monitoring system to make sure that you're not being attacked. They don't know. And so this issue of not knowing is the problem. So when you have an invalid operational security adherence, you have an invalid process. And what has to happen in a normal mitigation and control perspective is somebody has to investigate whether or not it had a material effect. But to the degree that we've looked at it, and to the degree that many others have looked at it, we haven't seen any kind of sensible end-to-end security framework analysis of the things that have happened. And in Georgia and many other places, there were significant breaches. And what I mean by a breach in this sense is that things were let into the system that were not allowed under the law. The determination of what is allowed is up to the states generally. Sometimes it's up to the federal government, but most of it, the policies, procedures, process, controls are all state law for the most part. And so what it means though is when 160,000 ballots that are legally required to have signature verification run on them, but they're counted anyway, it means that the operational security boundary of the election has been violated. And you now have 160,000 votes into the system that weren't supposed to be there. And because of the inability to cure that ex post facto, there's no cure possible. You don't know what happened. Now, there's been a lot of talk about this in terms of, the attempts to overthrow the election or change the election or outcome. I'm not talking about that. I'm talking about whether or not the election was valid. It was not valid by cybersecurity standards, simply not valid. And we had a little bit of discussion about my qualifications. This is my expertise. It's operational security and information security, cybersecurity, and resiliency. So there's no difference here with the election system and any other system that's done, whether you're talking about a bank or the CIA or the Georgia election system. And we have many examples of misconduct in this fashion. In Georgia, the failure to verify signatures on a large hunk of ballots. We've got, an unexplained 6,000 vote flip in another county other than Fulton County. We have not that there weren't attempts, and again, on the election challenges that were challenging outcome, no one could show whether those were Joe Biden votes or Donald Trump votes. That's not the issue. The issue is, what do we do about certification? Certification, at least from a colloquial standpoint, means that something is both accurate and compliant. And this compliance issue becomes a critical issue in the mixture of whether or not the election was reasonably certified. Because again, from a operational control perspective, it wasn't. That doesn't mean that there shouldn't have been an investigation. It doesn't mean that there weren't processes by which it would be possible to have cured it. I don't know, simply. No one has had the ability to really look at it in that amount of depth. People get upset about, the scanning that was done at night in Fulton County, as an example. The problem is the operational security requirements under Georgia procedures mean and as I talked about before, the Democrats and the Republicans are contestants on the opposite side of the map. It's a natural adversarial condition. It's assumed the rules of order, the treaty that exists between them is the election law. And so what happens when you see that election count going at night, it doesn't mean that those were Joe Biden votes. That's not what it means. It means that there was an operational security breach that introduced an unknown number of ballots into the system. It could have been Donald Trump votes. You don't know, but that doesn't make the election invalid or valid according to who the votes were for. It makes it invalid or valid according to the fact that these votes were introduced into the system against the rules of conduct of the election. And so I've seen this and read this many times in the judge's orders with regard to standing and a number of other things, materiality as an example, on the election contest. The real issue from a cybersecurity and operational security perspective was that there was a total breach of control. We don't know how many ballots were injected with improper signatures verification. We don't know how many ballots were injected, in improperly observed scanning at night at 2 a.m. or 12 a.m., whenever it was in the morning in Fulton County. These were against process, procedure, and by the way, the law. Now, the decision to prosecute, not prosecute, fine, fire, sanction, this is an adjudication and legal question. But the fact is that the election itself, under the rules of the election, using the risk management framework, were invalid. They were invalid. So you cannot attest to whether or not the mistakes were cured. You can't attest to whether they were material or not. The law requires that the system be able to measure the intent of the voter. If I can't tell you who won, you can't tell me that the certification was a proper one under the operational and cybersecurity laws that were in effect at the time.
All right, sir. So, does the certification process under FSMA and a risk management framework analysis entail examination of source code in the computer systems?
So you have a risk assessment issue, just to be clear. If you're looking at a machine and you don't know what it does, how do you certify it as being secure? And so we have these all over the country, including Georgia, where they signed contracts that protected the source code. So what you had there was an official of government signing a contract, which is at the lowest level of privilege, by the way, in the whole stack, going from the U.S. Constitution to federal law to state law to governance in the state, all the way down to the bottom. You sign a contract and it overrules process. A normal FSMA review requires a review of the source code. Now, you could say the source code wasn't required to be reviewed because of your secondary auditing and proving, but that would have to be done explicitly, not, haphazardly. And to the best of my understanding, it's been haphazard. So, do I have a comprehensive understanding of every single thing that was done everywhere? No, I don't. But the fact of the matter is the discussions have never covered the excuse that says that I can sign a contract, a purchasing officer in state government can sign a contract and overrule FSMA and federal law. That's what they're implying. The bottom of the stack, the bottom of the privilege stack, somehow makes it illegal to look at Dominion source code or Hart Civic source code or ES&S. It's not just a Dominion problem, just to be clear.
Okay.
Smartmatic and No Ink and VP Pro and all of them have these issues in their contracts, and clearly transparency is required. You understand, it's like buying a car without it being able to look under the hood, not necessarily.
All right, so let me just make sure that we're clear on the record. is it the case that the contract between Dominion and the state of Georgia prohibited examination of the Dominion source code?
I did not come to that conclusion myself, but people working for me that I have reason to believe came to that conclusion, as well as statements that were made by government officials denying access to the source code, that it was prohibited under contract.
All right, sir. All right, I am now going to change away from expert testimony to factual testimony and ask you questions about another incident. As you mentioned yesterday that you did some work with the Amistad Project and Mr. Phil Klein. As a part of that work, did you become aware of or acquainted with an incident involving an individual named Jesse Morgan?
Yes, I did. It was part of the Amistad Project. I participated at a reasonably high level. I was part of the daily meeting briefs in the morning by the lawyers and the operational people that were working on the project. And certainly I did become aware of the Bethpage, New York, Jesse Morgan story.
And what is that story?
That story was an independent contract hauler for the USPS, was hauling a semi-trailer full of what Jesse claimed to be pre-filled out ballots.
Mr. Howard, there's been an objection.
Yes,
Let me hear the objection.
yes, I'm sorry.
No foundation has been laid for this. He says he's been aware of a story. And I don't think that his awareness of the story, is a proper foundation. I think we ought to have a foundation for what he's testifying about.
I mean, at the moment, it sounds like he read a newspaper story and is relating it. Is it something else?
No, I was in the office where it was discussed.
Mr.
talked.
Mr.
I'm sorry. I apologize.
Okay.
I realize you weren't asking for an answer.
I wasn't asking you. I was asking counsel. Where does this go?
I can have the witness describe his involvement in this matter for the Amistad Project in more detail.
Okay. What I hear him saying, okay, is that he was in the office when that is discussed, which is a little different than I saw the person in the truck driving it. Okay, it's somewhat, and as we've discussed, I mean, hearsay isn't prevented in this proceeding, but it does go to the weight of it, and anybody can hear a story. Okay, but I don't know where it's going as to where it's going after he does it. So I understand your question to be, are you familiar with this story? And that's what he's saying as a predicate for other questions about it?
Yeah.
Okay.
So,
On that basis, the objection is overruled.
thank you, Mr. Chairman. Could you explain to the committee how you were familiar with Jesse Morgan and this matter at Bethpage and what you were just getting ready to tell us about? How do you know about it?
My first introduction to it was in operational discussions with Tony Schaefer and several of his PIs that were hired to try to find corroborating witnesses for the Bethpage matter. They had found Jesse Morgan as a whistleblower witness of this event. I had occasion to talk and be present in discussions with Jesse Morgan at length. In addition to that, I was part of the process by which Phil Klein prepared the report that he presented live on TV. I don't remember who carried it, but essentially the report of the Jesse Morgan incident. In addition to that, because my company, the company with whom I'm associated, has significant cyber forensic capabilities, including investigational capabilities. Phil Klein asked us to hire investigators or find investigators that would be capable of pressing forward on finding corroborating witnesses. We were engaged in that. We have an independent contractor that my founder of my company was directly involved with on other matters. We brought them in. We participated in the interview with Phil Klein as to what they thought they could do in terms of researching this information. Phil Klein proceeded to have the Amistad Project hire them. We were part of all of the debriefings and the presentation of the affidavits that were captured by from USPS employees other than Jesse Morgan, who was not a USPS employee, by the way, he was a contractor. But we were witness to the reading of the affidavits and are generally aware of them. So in addition, we were part of materially supporting testimony with regard to the Bethpage, New York matter outside of the Amistad Project, but that court case is sealed at the moment.
All right, sir. And did you report in to the government or any part of the government what you learned in the course of your investigation of the Jesse Morgan matter?
On the Jesse Morgan matter, no, we didn't. Our company did not report anything on that. We have made federal reports on other matters, but not the Jesse Morgan matter. Now, I am aware that it was reported to the FBI because I overheard conversations with FBI personnel and the Department of Justice regarding the Jesse Morgan matter.
All right, sir.
Again, you have to understand we had two operational rooms. I was present for these discussions that were on speakerphone.
All right, sir. So tell us what the Jesse Morgan story is.
So Jesse Morgan's story is that he was hauling a semi-trailer from Bethpage, New York to Pennsylvania. He became aware as he picked up the semi-trailer that it was carrying Pennsylvania ballots. This is the story. I've got no independent corroboration of this myself, other than the affidavits given to the Amistad Project and to the investigator, well, originally to the investigators, that this was in fact, in fact happening. So then, there were several discussions over time. Tony Schaefer and his people were handling the investigation originally. This other contractor took over the actual work at Bethpage to find corroborating witnesses, and they did. 3 other witnesses.
All right. Were you present when Mr. Schaefer received a phone call from a senior official of the Justice Department?
Yes, I was.
And was that, were you able to hear both sides of that conversation?
Yes, and about 6 or 7 other people were able to hear that conversation.
And so was it on the speakerphone?
Yes, it was.
And who was the, who called who?
Bill Barr called Tony Schaefer.
The former Attorney General, Bill Barr?
At that time, he was the Attorney General.
All right, sir. And tell us about that conversation.
It was relatively irate, and he was telling Tony Schaefer to stand down on this investigation. It was not a long call.
And what was the response to that directive from the Attorney General?
It was kind of ambiguous, but it was sufficiently strong to say that the evidence had already been found, and the response was, "I told you, you need to stand down on this."
And
the conversation was not long. It was agitated, to say the least.
all right, sir. Was Mr. Schaefer or your team seeking anything for Mr. Morgan?
My team was not seeking anything, nor were the investigators that we brought in that Amistad hired. They weren't seeking anything either. The other team was paid some fees to do the investigation. I don't know what the nature of that contract was. It was between Amistad and that team.
All right, sir. Was there any discussion of whether Mr. Morgan would be entitled to whistleblower status?
There had been discussion all along as to whether he was entitled to whistleblower status, but to the best of my knowledge, that was never made available to him by the Justice Department.
Did that come up in the discussion with Attorney General Barr?
I simply don't recall that. It may have. I know what Tony Schaefer says about the conversation. He put it out in the public, but the fact is that I do remember the exercised instructions to tell him to stand down. I wouldn't say that I wasn't really thinking about it in the broader condition of things at the time, to tell you the truth. We were overwhelmed by other work that we were doing to try to figure out what happened in 2020.
And do you remember about when this phone call took place, the call from?
I believe, to the best of my recollection, it was in early December, maybe mid-December of 2020.
All right, sir, that's the questions I have for you. Thank you very much.
Mr. Fox.
Mr. Howery, let me start with the last thing that you discussed. What is the Amistad Project?
Amistad Project was a effort initiated to try to control private donations supporting federal elections, generally characterized as Zuckerbucks in the mail-in balloting system.
And the idea
It was managed by Phil Klein. The chief litigator was Eric Cardall.
and the idea was to prevent contributions like those made by Mr. Zuckerberg to state election officials. Is that it?
Well, state election operations, yes.
Now, Mr. Morgan was an independent truck driver, correct?
Correct.
And his basic story was that he was driving a truck and somebody, well, I guess either he was at a rest stop or something and somebody took the trailer, it disappeared, correct?
It didn't disappear. He left it off in a designated location and somebody else picked it up.
Okay.
Under
And
the instructions of his company.
right. And did you look into whether Mr. Morgan had a criminal background?
I have since become aware that he has a criminal background, but I didn't know that at the time. It wasn't part of my job. So
Now, you indicated he hadn't been granted whistleblower status.
to the best of my knowledge is what I said. I don't know that it was.
Let me finish the question. What's your designation of whistleblower status?
So there's several different things. The word is used so loosely. I mean, you have government employee whistleblower status, you have witness protection program status. Often people on a colloquial basis refer to people that are protected in some fashion from retribution or prosecution as whistleblowers. So I would argue that this was a colloquial conversation with the general colloquial understanding of what whistleblower means. They were looking for witness protection over Jesse Morgan. I know what they were looking for, but they were describing it as whistleblower status.
Who is the they that is looking to put Mr. Morgan in the witness protection program?
Amistad was trying to sponsor with the DOJ witness protection over Jesse Morgan.
And from whom was Mr. Morgan to be protected?
They were concerned he would be harassed significantly by people that whoever it was, you know, if the story was proven to be true, or as it might have been proven true, they were concerned that there would be retribution by the parties that were part of that action, whoever they were. No one knew who they were, at least not at that time.
Tony Schaefer was some sort of investigator, is that correct?
He was acting as a private investigator for the Amistad Project.
And
He's a former SOG officer, Lieutenant Colonel Tony Schaefer.
your testimony is that the Attorney General of the United States called this private investigator and told him to back off?
My testimony is that I heard the conversation with Tony Schaefer. His voice sounded like Bill Barr. Bill Barr has a very distinctive voice. And Tony Schaefer at the time declared that it was a call from Bill Barr. I don't know beyond a shadow of the doubt that it was Bill Barr or not, except he has a very distinctive, easily recognized voice.
And you did testify that the FBI investigated these allegations, correct?
I testified that the FBI was supposed to investigate the allegations. I don't know whether they ever did or not.
You also,
They don't make their investigations public typically.
well, we'll come back to that in a second, but are you also aware that the postal inspectors investigated?
Yes.
And are you aware that the Inspector General for the Postal Service issued a report about these allegations?
Yes, I am aware of that report.
And the report found that they could not support the testimony of Mr. Morgan, correct?
That's not what it found. It found that they didn't know what was inside the trailer.
Okay. But they could not corroborate that any election ballots had been hijacked or whatever the proper verb is there, correct?
The way it's properly characterized is that they don't know.
Okay.
So they said they couldn't corroborate it. It means they don't know. They didn't say categorically that it wasn't true. They said they don't know.
But it was investigated by an agency of the United States government, correct?
Correct.
All right. Now, let's go back to the expert aspect of your testimony. I think I heard you say towards the end of that many states didn't meet the cybersecurity standards in the 2020 election.
That's correct.
And
At least the cybersecurity standards that apply to federal law.
right.
There were a number of waivers offered by people that may or may not have had legal authority to do so.
And so, and as I understand your position is that if the states don't meet those cybersecurity standards, then the elections are invalid in those states. Correct?
My position is that certification declares not only that the count is accurate or the tallies are accurate, it also under federal law declares that it's compliant with the operational procedures or the law that applies to that process.
And so, and as I think you made the point twice yesterday and once today, you're not testifying that the count isn't accurate. You're testifying that the cyber security procedures were not compliant, correct?
No, that's not correct.
Did you not tell us, I think, how you put it earlier today, that you were not saying that the results should have been in favor of Trump or it should have been in favor of Biden. You were just saying that the process was a problem.
No, that's not what I said.
All right.
I said that they don't know who won.
They don't know who won. Okay.
Not according to the law. That's what I'm saying.
Okay.
And I'm talking about the policy and procedure that's endorsed by law. I'm not making a legal decision here. I'm telling you that the way that the elections are supposed to be conducted is clear, and they didn't conduct them that way. The election certification and whatnot is based on this treaty that exists that we call the law, an agreement between the contestant parties as to how the election is supposed to be conducted. It wasn't conducted that way. It was a violation of the law. So how can you certify compliance with the law, particularly when you don't know what those votes are? You don't know if they're legal, legitimate. They don't meet the legal requirement under election law. Just to be clear, the way that we refer to it in election operations is that an improperly counted ballot that doesn't have legal validation associated with it is literally called an illegal ballot. The acceptance of an illegal ballot is called election fraud. Now, does it need to be adjudicated, investigated? Absolutely. I'm not making a legal conclusion about the outcome. I'm saying that there was never any investigation that legitimately determines whether those hundreds of thousands of ballots that were let in could be ignored from a materiality standpoint. And this is what everybody's calling everybody to do, is to ignore the operational security breaches of the election, which were massive. This isn't the imagination of somebody. It's against the rules.
When you're saying ballots that were let in, you're referring to ballots that were counted in the election and the process was not adequate under the cybersecurity standards. Is that correct?
No, it wasn't adequate under the state law.
Okay.
It's worse than just under the cybersecurity standards, but those are part of the operational security. They're part of the risk assessment. You cannot have a total breach of the system and call it certified anymore. It's not the way it works.
Can I request that the witness answer the question? I'm just trying to understand what he's saying, and he's arguing with me about it.
I mean, I think you have an answer to your question.
But let's focus on Georgia. Was the Dominion system that was put in place in Georgia certified by the U.S. Election Assistant Commission for use in Georgia?
Under a waiver, yes.
Okay. And that was...
I'm not sure that waiver is legal. It certainly doesn't comply with FSMA.
Okay. But it was certified in advance by the United States Elections Assistance Commission, correct?
There was a certification letter issued by the EAC, yes.
All right. And before that happened, Georgia went through a fairly elaborate process to decide whether to use this Dominion system. Are you aware of that?
Yes.
They had something called SAFE. Do you know what SAFE was?
So I'm not familiar with SAFE as it applies to Georgia. I'm familiar with SAFE as it applies to other places, but it takes the operational rules and conduct and procedures and process and decides whether or not something's safe. This is the assessment framework I'm talking about. But when they decide not to follow those rules, is it still safe? Is it still certified? We'd call it a total breach in our industry.
Mr. Howery, SAFE in Georgia referred to the Secure, Accessible, and Fair Standards Commission. Secure, Accessible, and Fair Elections Commission. Are you aware that there was such a thing in Georgia?
Yes.
All right. And it assessed the voting system for 9 months, correct?
It assessed the rules associated with the conduct of elections for 9 months before the election. That's true.
It's chaired by Republicans, correct?
I don't know who the chairs were. I simply am unaware of who the people were.
And there was an overwhelming vote, 13-3, for a ballot marking device with verifiable paper ballots. Did you understand that?
I know that it was approved by them. I don't know what the vote was.
And then the Georgia legislature approved that recommendation, correct? That would have been April 20.
Again, I'm not technically familiar with what happened with regard to their approval, but if you say so.
Are you aware that the Secretary of State held a competitive bidding process to establish to whom to award the contract?
I am.
And are you aware that Dominion was selected as a result of that process?
I am.
And there were lawsuits thereafter concerning that, were you not? Were there not?
Yes, I'm aware of that as well.
And indeed, there was an attempt to enjoin the use of the Dominion system in the late summer, early fall of 2020 that was essentially unsuccessful, correct?
I'm familiar with that as well.
And then the system was used in 4 elections in Georgia before the November general election. You aware of that?
I am not aware of the specific revisions. I believe that the system that was approved by SAFE was changed. I'm not familiar with the source code review that allowed a system change to be made. Normally, it requires a separate and additional review. I know that those separate and additional reviews were not. You asked me a question, I'm answering
I
it.
did not ask you about
Hold
the
on,
story.
hold on, folks. You were talking over each other, which is going to make it impossible for our court reporter to have a record.
I apologize, Mr. Hirsch, but this gentleman is not responding to the question. The question that I asked him was whether the system was used in 4 elections before the November election, and he started talking about source code.
Well, as I understand what
This-
you're saying, okay, Mr. Fox, it's a question of what the system was, and he was suggesting the system may have been changed. Now, maybe it was, maybe it wasn't, but if it, if it was, that is responsive to your question. I think you can clarify that.
Are you testifying that the system was changed or that it's?
Yes,
You was, and you know that how?
I know that because it was told to us by the election commission that they accepted changes to the code that was running the election.
Could we look at exhibit 36, please? You testified several times about, you mentioned this CISA, C-I-S-A, is that correct?
Yes.
What does that stand for?
Cybersecurity Infrastructure Security Agency.
And that CISA was part of this joint statement that was issued after the November election, correct? Is that correct?
It doesn't say that, no. I'm not saying that that's not correct. It doesn't say so in what I can read on my phone.
If you, well, maybe you can't see it on the phone. Joint statement from Elections Infrastructure Government Coordinating Council and the Election Infrastructure Sector Coordinating Executive Committees. And then it says at the bottom that the members of the committee are Cybersecurity and Infrastructure Security Agency, CISA. So it was part of the group that issued this statement, is it not?
First of all,
Their membership in the group doesn't mean that it was a CISA certification.
Mr. Fox, first of all, why don't you make it larger so maybe he can see what you're reading from?
Sure.
And
Let's
also,
go to
I
the
think you
first-
cut off, you didn't say everything it said.
Let's go to
Okay,
the first.
so I just want you to
Let's go
ask
to
him
this first
those.
paragraph. So it says the members of this complicated name committee include CISA, correct?
Yes,
CISA assistant director, correct?
yes.
All right. And let's go to the next page. It's second paragraph. The November 3rd election was the most secure in American history. You have any reason to disagree with that?
I do.
Okay. And let's go on down and look at the blackened letters in the next paragraph. There's no evidence that any voting system deleted or lost votes, changed votes, or was in any way compromised. Is that something you disagree with as well?
Yes, I do.
All right. Could we show the witness disciplinary counsel exhibit 78? Maybe can we make that a little larger because he may have a difficult day. Thank you. And what I want to do first in showing you disciplinary counsel exhibit 78 is go to the signature pages. Can you do that for us, Emily? And just, do you recognize any of the names on this page?
Yes, a number.
And would you agree that they're cybersecurity experts?
Not necessarily.
Nobody on this page is a cybersecurity expert?
I don't know what they are. It doesn't tell me what their qualifications are.
All right. Let's go to go start with.
I can tell you that the secretary or the person in charge of CISA at the time is a lawyer. It's not a cybersecurity expert. I don't know anything about any of these people. in
Okay.
terms of what their personal qualifications are. The other thing is I don't accept this as an official representative exhibit of anybody testifying under any kind of seal of authority or seal of responsibility or the fact that they even know what they're talking about. This is just a general document used in the ongoing information war that exists between people. If you want me to have a conversation with any of these people, I'd be happy to.
Let's look at the first page.
But I don't know if any of these people have cybersecurity. Just because I'm a CEO of something doesn't mean I know what I'm doing from a technical or a technology standpoint, or a deputy head or anything else. It doesn't say that. And this statement that it didn't have any violations and there was no evidence is a completely unfounded conclusion. So I have to say that this document means nothing to me. We know already from adjudication that they refused to do the signature verifications of over 100,000 votes in Georgia. This by definition means that this didn't apply.
Okay.
So it was neither safe or secure.
Well, we'll come back to the signature verification in a moment, but I think we're finished with this document then. Are you aware that there was litigation in Georgia after the election that challenged the insecure procedures with respect to the voting machines?
Yes.
And that litigation is unsuccessful, correct?
Well, parts of it have been successful. There's been many findings of misconduct or inappropriate use of systems and inappropriate use of the election process.
But
And at first, I mean, most of the original litigation was oriented toward challenging the outcome. I'm not talking about outcome. I'm not saying anything I have shows that Joe Biden didn't win or that Trump did win. I'm not saying that. What I'm saying is that the system wasn't followed. You talked about the SAFE system as an example. The system wasn't followed. How can you claim safety in the system with 9 months of pre-election work that's ignored during the conduct of the election? It's not safe. The 9 months that they did isn't safe. It's whether they followed the process and procedures that were oriented toward the risk assessment. And so looking at things ex post facto or prior to the election doesn't mean anything. What means something is we now see evidence of significant variations in the way that the system is supposed to work. And so I have a car that's able to drive a certain number of miles per hour down the highway. That doesn't mean that it's not doing something unsafe on the highway. It's how it's used. And you know, if I've got the gas pedal to the floor, that's how it's being used.
Are you aware that there were three counts of the vote in Georgia, 3 separate counts?
Yes.
And there was also a signature audit that was conducted, correct?
There was a signature audit conducted after the fact.
Right. And the Republican Secretary of State vouched for the results of the election, correct?
The Secretary of State, I don't remember who the election official is in the state that is responsible for certification. I believe it's the Secretary of State in Georgia. Maybe in most states, it's either the Secretary of State or the head of the election board, or sometimes it's co-heads of the election board.
Have you heard the name Raffensperger?
Yes, of course. I know he's the Secretary of State of Georgia.
And he vouched for the outcome of the election, correct?
Are you asking me whether I know that he vouched? I do know that he said that the election was a solid election. I know that.
And the governor of Georgia certified the election results, correct?
I don't know I don't know what the procedure is in Georgia, to be quite frank. It's not a fact I'm totally aware of in Georgia. It would be very rare for the Georgia governor to be the official HAVA designated federal agency, but if it is, it is. I'll accept that it's possible. but it's usually either the Secretary of the State or the head of the election board that certifies the election.
Well, I'm sorry, I meant certified, the person who certified it to the Electoral College was the governor. Correct?
I don't know. I have no independent knowledge of that.
Are you aware that every case challenging the results of the election in Georgia failed?
I am aware that there was no, the cases failing and being eliminated on standing are two different issues, but I do know that none of them succeeded in overturning the election results, if that's what you mean.
And have you seen the report that the Secretary of State of Georgia made that's dated January 6th to the congressional delegation?
No,
And so you're unaware of what he said. You testified, I think, and I've forgotten the number, but I think you said that something like 160,000 unverified absentee ballots were counted in that. Am I quoting you correctly?
I know it's over 100,000. I don't know how many exactly. The 160 I was referring to are the 169,000 in Pennsylvania.
Oh, in Pennsylvania.
I was talking about all over the country. There are these variations of law.
Oh, you weren't just talking. You weren't talking about.
No, if I misspoke, I apologize, but I don't know how many didn't get verified. I have no idea. I actually do know, but I just don't recall. I mean, I knew at one time I reviewed the report that had the number of ballots that were not signature verified, but I don't recall the number off the top.
And but you have not read the report from the Secretary of State, which discusses that issue?
Not at all.
Now, the other thing that I think that you did say about Georgia was the stopping the count in Fulton County, correct?
No, I was talking specifically about the counting of ballots in Fulton County after the counting had been, quote, stopped.
All right, I thought that's what I said, but in any event, this is the State Farm Arena incident.
Yes.
Okay, you're aware that that was investigated by the Secretary of State?
I am aware that they've done work to try to figure out what happened there and have made conclusions that they're exonerating themselves.
And you're aware it was also investigated by the FBI?
I am not aware of what steps the FBI took with regard to investigating that matter.
Nobody told you that the FBI reviewed the entire surveillance tape from the State Farm Arena?
What I'm telling you and what I said to begin with was the operational process that was certified in Georgia was broken at that moment in time. Did it mean that does it mean that Donald Trump won the election? No, it doesn't. Does it mean that they violated the law when they were conducting the election? Yes. Why the DOJ decided not to prosecute election misconduct? I have seen no detailed report or analysis of what work that they have done in that regard. And I wouldn't accept some general political statement that they were okay in everything that they did. They were, after all, the ones that conducted the election. One of the big objections I have in this whole process is that we don't have a meaningful audit system in place. Nobody ever audits themselves. It's an oxymoron.
Well, I'm talking
Risk
about
limiting audits don't mean audits either, right? You used the issue earlier, but risk limiting audits don't measure everything that occurred. It's only 3 very small divisions of what occur during an election.
Mr. Howard, the FBI did not conduct the investigation in Georgia.
You said that they investigated.
I'm sorry, I misspoke. Did not conduct the election in Georgia.
I didn't say they did.
Well, you said that the investigation was not independent from the people that conducted the election.
I don't know what the FBI did.
Well, I want you to.
I do know from my own experience that the FBI didn't do a lot with regard to the election matters at hand. There are thousands of affidavits that were submitted that never got investigated. So, you know, the statement that everything was okay about something that they never looked into deeply, I don't know what they did. I have no idea. Telling me that they issued some political statement saying everything is okay doesn't convince me that everything was okay. You show me some detailed analysis and description of what they did, and we can talk about it. But I do not accept that the FBI rigorously investigated any of these matters.
Okay.
Particularly after it was obvious that the election was going, you know, the election decisions were going to go ahead as decided.
So you don't know what the FBI did with respect to the State Farm Marina, but you would not accept the FBI's conclusion that nothing improper happened. Is that your testimony?
I would not accept that, because we know now, after years of investigation, that is simply not true. Lots of things happen
At the State Farm Marina.
at the State Farm Arena and other places in Georgia.
Those are all the questions I have.
Mr. Howard, I just have a couple of questions for you. You were asked whether you agreed with the statement made by a variety of federal cybersecurity officials that it was the most secure election in history, and you said you did not agree with that. Tell the committee why you do not agree with that.
Well, I agree because there were sizable, you know, situations that existed of proving breaches of conduct, breaches of the operational security boundary of the elections that were plainly obvious, including the videotape of the Fulton County vote. This is completely against the rules. It's a breach. Now, can they prove that it altered the outcome of the election? Absolutely not. But is the election valid? Was the certification valid? Did they certify a system that said you can vote anytime you want without any observers? No, they didn't. The certification itself was obviated by the misconduct. It was misconduct. Why the state didn't prosecute that? Why the federal people didn't prosecute it? It's politically difficult to do that at the current time. But the fact is, it's plainly obvious that they didn't follow the rules. Whether it had a material impact, no, you can't tell that. But can you certify it? No, you can't. You can't certify something that doesn't meet the certification boundaries. It's a defined system. They didn't behave the way this defined system says you have to behave. And so I don't accept somebody, you know, washing their hands and saying everything is okay. Don't look behind the green curtain. This is what they're saying over and over again. The plain fact of the matter is what they were doing was not allowed, and it was part of the certification boundary. Therefore, they destroyed the certification when they conducted the election, not in accordance with the rules, in a material fashion, by the way. And my materiality here, I'm not talking about the result. I'm talking about whether the misconduct was large enough, if it was not random, whether it was large enough to sway the election, and it was. Does that mean that somebody else won? No, it doesn't mean that. What it means is that the conduct of the election was illegal under the use of the term that the DOJ itself uses in its own prosecution guidelines, the plain English term. I can't explain why they decided what they decided. We have DAs and attorney generals of the United States and states making decisions on prosecutorial discretion all the time that I don't agree with, but I don't have any way to pass on whether or not their decisions were proper from a legal perspective. But I do have an ability to determine that this election was not conducted according to the rules, and those rules had potential material effects. And the problem with an election is you can't reverse it. You have a voter and a vote, and at one time they're connected, whether it's a mail-in or it's a in-person vote. As soon as they're separated, there's no way to reverse the damage. The correct way to reverse it is to redo it, but that's a politically inopportune, perhaps, recommendation. But the fact of the matter is when you have a material breach of conduct, which it was large enough to affect the election result, which it was. The election should have never been certified to begin with under the rules that are stated as to what certification means in plain English. I'm not talking about the law and the implications. It's not a legal piece of advice. It's an operational piece of advice. It says that the certification says that the election was conducted materially and effectively in a similar fashion to the rules, and it wasn't. It was not. That's my testimony. It was not conducted according to the rules.
Thank you very,
And in a system, I'm sorry, go ahead, I'm done.
I'm finished. Thank you very much.
Anything further, Mr. Fox?
No.
Anything from the panel? No. All right. Thank you very much, Mr. Howry. I really appreciate your time and again for coming back today to complete your testimony. You were excused.
Thank you. Bye.
Okay. So what next? Are we ready for Mr. Smith? Is that what's going on?
I've just asked him to come into the waiting room and hopefully he's trying to find a link. So let me send him.
Okay. And as I recall, he completed his direct. So this is, we're going
That's
to
correct.
pick up with Mr. Fox's or Mr. Oral's cross-examination. And be it known, this is the first time I've gotten the pronunciation of his
It's okay.
name right.
Thank you.
So we should spend a moment to focus on this moment.
Could Ms. Barasas confirm that the link is the same for each?
Yes. Yes, it's the same for every day. I was about to chime in.
I've just sent it to him.
Okay. All right. He is in the waiting room. I'm letting him in now.
Mr. Smith, thank you for making time this afternoon. Can you hear me?
Yes, sir.
Okay. I remind you that you're now under oath. When you testified on Monday, you completed your direct examination. So Mr. Hall from the Office of Disciplinary Counsel will be beginning your cross now.
Thank you.
Good afternoon, Mr. Smith. I've just got a few questions for you. Mr. Smith, you previously described yourself on Twitter as not an election denier, but as an election abolitionist. Is that right?
That's correct.
And that's because your position is that no electronic voting machines should be used in any election at any level of government in the United States?
That's correct. But that's not why I said that. It's not just about, so, I mean, you're familiar with the term abolitionist and with respect to slavery and its history within the United States. So it's my perspective that if we do not have citizens, do not have complete transparency and control over our own elections, the ability to verify for ourselves that in fact elections are the result of legitimate votes cast by eligible voters and accurately tallied, then we're not receiving what we are guaranteed in the Constitution, which is a Republican form of government, because we don't know that our government and its representatives are the result of that collective expression of consent and will.
And so it's your position that voting should only be performed on paper ballots that are hand counted on election day at individual precincts. Is that right?
That is my position. And I didn't come to that position accidentally, and I didn't hold that perspective when I first began looking into election systems. In fact, in April of 2021, when we briefed a group here in Colorado of Republican state legislators, at that time, I still thought it would be feasible to use what I called a simple and secure scanner that just produced images onto a removable write-once media. But I realized that even if you could do that, and you could, it would be an engineering challenge, not a scientific challenge, that citizens would still be asked under those circumstances to trust some expert. And, I've been an expert. I know a lot of experts. I don't want anybody to trust experts. I want them to be able to see it for themselves, because otherwise it will be continuing and repeatedly susceptible to manipulation. And whereas if citizens can see it for themselves, if they have transparency, they'll be able to see that. So I didn't start off, I guess, what I'm trying to say with the perspective that machines are bad. I've employed, sensitive and exquisite technologies in the course of my duties. Over the course of decades, I've specified requirements for them and tested them. But in this case, what we're talking about is placing complex technology with a sham of verification and testing into the hands of people who are not capable of even understanding what they're being asked to employ, let alone whether or not it's been corrupted. And you're not going to improve that with more testing, because you're still going to put those same devices into the hands of election officials, and none of them, from what I've seen, have the expertise or background to be able to even verify that those machines haven't been permuted in the supply chain. I read the comments from the EAC to their 2021 voluntary voting system guidelines, and they stated unequivocally that it wouldn't even be possible for the voting system testing labs, which we're asking to certify that these systems comply with the voting system standards. It would not be possible or feasible for those labs to be examining the internal components in the voting systems, even in the exemplar. And if that's not happening, there's zero chance of securing those computers. And if you can't secure them and they're being procured as they are from overseas unsecured supply chains, manipulable and accessible by foreign powers, then it's like giving away control of our country.
And it's your position that things like electronic voting machines, absentee ballots, and early voting are links in the chain that lead to rigged elections?
Well, I think there's not just one. So, understand Twitter is a very short form. Once upon a time, I said if you had nothing to say it, Twitter's a good place to say it. But it's very terse and concise. And so you kind of paint word pictures. You can't go into detail. I'm happy to go into detail about that. There's not just one mechanism that's being used to corrupt our elections and to make them more vulnerable. There are multiple. And among those are black box voting machines, just like Bev Harris said in her 2002 book, just like the brothers said in their vote scam book, just like Sheila Park said in her 2012 book about getting rid of electronic voting machines while we still have time. This is not a new idea, but the problem has accelerated. Among the other problems are mail-in ballots with weak or fraudulent chain of custody and assertions of legitimacy based on, signature verifications by amateurs based on a database that isn't being secured and is provably inaccurate. And then you have the problems with the voter rolls themselves, which we could go into any amount of detail you'd like to about.
That's okay. I don't have any further questions.
No redirect.
Okay. Does the panel have any questions?
No.
All right. Thank you very much, Mr. Smith. Really appreciate your time. And you are now excused.
Thank you. Good day.
Good day. Okay.
Mr. Chairman, I'm going to turn it over to Mr. Burnham at this point.
Thank you, Mr. Chairman. We are coming to the close of our case, and I want to address the court on what's a remaining outstanding question, which is Mr. Clark's potential, still at this point, testimony. I come mostly from the criminal side of the law, where you always have one last discussion with your client before he decides or she decides whether or not to testify. And that's kind of where we're at here. And so what I'm coming to is this, is there still, even at this point, could be a potential for Mr. Clark to waive the Fifth Amendment right he's been asserting so far, and which has been validated by our Court of Appeals. But one of many factors relevant to that are the remaining privileges that Mr. Clark has been asserting along with the Fifth Amendment and asserted indeed in the course of this proceeding. Where those stand, of course, is the panel has denied our motion in limine filed prior to the hearing, seeking to exclude testimony on the basis of those privileges. And with all due respect to the reasoning of the order and the effort that the panel put into it, it relies on, out of district cases, the federal court in DC. There's not a Supreme Court case or indeed a Court of Appeals case that sort of directly answers the question posed in that motion and in the committee's order. So all of this by way of saying, if Mr. Clark were to waive his Fifth Amendment right and take the stand in his own defense, he would essentially be abandoning all ability to test the committee's order through the appellate process, which is an untenable position to put Mr. Clark in, we would suggest, particularly in light of, the importance of some of the privileges and the information at issue. And so the relief Mr. Clark would like to ask for, and I understand this might be an unusual request, but if I can expand on it, I don't think it's as unusual as perhaps it might first sound, is to recess the proceedings to take an expedited appeal to our Court of Appeals. There's two reasons why I think that's entirely feasible. One is my review of the board rules has certain forms of interlocutory appeal. I saw two that are specifically excluded. Privilege interlocutory appeals is not one of them, and I didn't see a general prohibition that would apply to that. Secondly, procedurally, I think that a case that might be instructive that's been adverted to several times by disciplinary counsel is the Eastman matter. Obviously, that's in a different court, but there are some similarities. That case involving several novel legal issues, as it does, and as this case does, started and stopped multiple times to help resolve those issues over the course of the better part of 2023. We're not asking for any kind of lengthy procedure like that. What we're asking for is a very brief recess to attempt expedited appeal to the Court of Appeals. And there's reason to believe that slow though the Court of Appeals sometimes is, that they would be able to act expeditiously based on our experience with ODC Counsel's motion to enforce, where once we were able to get their attention and they were aware of the schedule, they promised to get a ruling far enough in advance of the trial not to delay things, and they absolutely followed through on that. And so that would be our request prior to resting our case.
Mr. Fox?
Thank you.
I am not aware of any vehicle to even, first of all, I oppose it, make that clear. Second, I'm not aware of any vehicle to do this, any procedural vehicle, how you would do that. To interrupt a proceeding to take an interlocutory appeal without any sort of, the court reviews final judgments, and in this situation, what it reviews is not the hearing committee's report, but the board's report that follows the hearing committee report. There's no, I don't see how you could do it. And secondly, those other arguments are frivolous. Those privileges have been waived. There is a pretty definitive case from I'm trying to remember now whether it's the district court or the Court of Appeals from the federal side that specifically said that President Biden waived the privilege. Former President Trump, to the extent he had a privilege, did not assert it when Mr. Rosen and Mr. Donahue testified in front of two congressional committees, January 6th committee and the Senate Judiciary Committee. Mr. Clark exercised his Fifth Amendment privilege there, but nobody's ever ruled that these other privileges applied or even existed. You've already ruled on that, either the district court or maybe the DC Court of Appeals, and I frankly can't remember without, I'm standing here now without looking at my notes that I don't have with me, has ruled against it. And there's no procedural vehicle to do so. So no, I oppose it. And I think we ought to go to closing arguments.
Brief response before the second. There's actually just 2 points. One is what we just heard mostly from disciplinary counsel is a rehash of the argument on the merits as to why the motion to eliminate was properly granted in ODC's view by the committee, which is not really pertinent to the request I made. I'm happy to rehash our arguments as well. And I think we have perfectly good answers to everything Mr. Fox mentioned. But the question before the court, I think, is a procedural one. And our basic position is that through a sort of doctrine of negative implications, sort of, is if the rules say there's no interlocutory appeal for A and B, which they do as to certain specific questions, the inference of that is that an interlocutory appeal does lie for those issues to which it's not specifically forbidden by the board rules. And then my client, third point, my client is asked to address the court personally. It is his testimony. It's his privileges and his Fifth Amendment rights that would be at stake were he to reconsider his decision. So we would ask to address the committee himself with the committee's permission.
Well, all right. Let me pause on that. I don't want to, I'm cautious about putting Mr. Clark in the position of making statements and then me having to ask him questions when he's trying to assert privileges as to things. It's an awkward situation that actually occurred in his testimony when he said, well, my client's the president, and then the Fifth Amendment was invoked to support it. In your role as a lawyer, you have a responsibility to make candid responses to questions. And then I have to go, should I not ask a question that I think is relevant because this may lead to the, Mr. Clark waiving, and I really want to avoid that, even the possibility of that scenario.
I think it's not compelled. If he's not on the stand, it's not
No,
compelled.
I understand, but if he makes public statements in this room, those can be used in a criminal proceeding. He doesn't have to be under oath. But look, I'm having conceptual problems with what you're asking for, okay? You filed a motion in limine directed to really Mr. Rosen, Mr. Donahue's, and potentially other testimony that either didn't happen or whatever, but whatever, about the significance. And, I tried to use a little more precise terminology in the order. Okay. People refer to the term, quote, executive privilege in 2 ways. I think the proper use of the term is it's a group of different privileges that can apply to the executive branch and includes different elements with different standards. But it's frequently used to be more to a limited reference to a presidential privilege involving communications with the president by and large. But as I understand it, I mean, you made this motion in limine to try to prevent other testimony, which I rejected. Okay. So we had the testimony. And now you're saying, and when Mr. Clark testified, he said, well, I'm not going to testify for these 5 or so reasons that he recited during his testimony. It sounds like and now he's considering the possibility of waiving his Fifth Amendment privilege. Now, that part of it, I understand. Fifth Amendment privilege is owned by him. He can waive it. He can assert it. That part I have no problem with at all. But it sounds like what you're doing is taking an appeal to see if he loses the argument that these other privileges apply, so that the Fifth Amendment waiver would result in his testimony is what you're asking. You're trying to see if you lose. Because if you win, we're still in the same place we are now. He hasn't testified and he wouldn't testify, right? Because he's asserted all of these privileges. Is that correct?
Yes.
Now, from my standpoint, there are a couple of, and what I don't know is whether if he loses in the DC Court of Appeals, he then needs to seek review from the US Supreme Court of that decision and whether we're talking, that peer process. And now, I haven't gone back to look at the procedural vehicles for interlocutory appeal, but assume you're correct, okay, that there is a way of doing this. Here's our process, right? We hear evidence, we sit down, we write a report and recommendation. We're supposed to try to issue our report and recommendation in 6 months, okay? To be absolutely candid, sometimes it takes longer than that, but I try to keep to the schedule that's in the rule, but that's what it says. It's supposed to be in 6 months. And before that, we get briefing from both of you on all of the issues. That's the process, right? Then whatever we say gets reviewed by the board, and that takes an additional period of time. In my experience, it can take quite a lot of time. It could be a year or, for their whole process of having briefing before them, an argument before them, and then issuing a decision. There is a procedure in the rule to request a reopening of the record for good cause. Okay, so it sounds like you don't need to recess this proceeding in order to pursue the arguments you wish to pursue. We can still start working on a report and recommendation, and if there's a change and you make a motion to now that Mr. Clark would like to testify and would like to waive it, and that motion, is otherwise, valid, then it happens then, and nothing has actually happened so far as this proceeding is concerned. Okay, so I'm not inclined to think that the remedy you're seeking is really necessary to the nature of the proceeding. The final point, and I won't give specifics, but we are aware of them, is that, there's some risk that delaying things for a short period of time may mean delaying things for a long period of time for other reasons. And I'm concerned about having that happen too. It's been a while for this case to come to the hearing in the first place. So my inclination is to deny your motion. You're free to pursue the remedies that you have, regardless of that. But I don't see that it needs to happen in that way. The one other thing, which is a point I believe we, mentioned in the decision motion limine, there is a provision that allows lawyers to testify in their own defense in connection with disciplinary charges. With regard to the attorney-client privilege being an impediment of a lawyer defending themselves. But, I don't know whether that covers the universe of all the things that you want to assert. I'm not purporting to say it does. Okay. I'm saying that sounds like the procedural, route whereby you can preserve your argument without delaying this proceeding, even if I accept the rest of your argument and assume that you do have a vehicle for seeking this review. I don't think California's procedure is at all similar to, I have litigated in California. California has a very easy process for interlocutory appeals of all sorts of things. And routinely you can file a request for interlocutory appeal at any time from a trial court to the appellate level courts in California. I don't know that system is exactly replicated in any state, but that is kind of an unusual California thing. So I don't know that what happened in the Eastman case really informs what happens here, but I haven't researched it. You just brought it up. I'm just relying on my recollection.
Could I make just a few points in response, sort of in reverse order to the points of the chair? One is I take the chair's point that there's another vehicle to get at this issue prior to the board's decision being formalized, but that runs the risk of not really advancing the ball if, for example, the board were to deny reopening the record, which could happen for good cause. Then we'd be in the same position of seeking to take an interlocutory appeal at that point, and Mr. Clark still will have missed his chance to potentially testify in his own defense in the context of all the other evidence. By that point, we'll be pretty far down the line. Secondly, in terms of the disciplinary provision, I think Your Honor, Mr. Chairman was alluding to one of the comments to Rule 1.6, which is permissive. The privileges may be waived. It doesn't specifically address executive privileges.
I honestly think, but I can't put my finger on it. I believe there's a board rule on it too, but in any event, if I'm wrong, I stand corrected on that. I haven't memorized the board rules either.
It's a permissive, and I think our position would be in the context of executive privilege involving conversations with the literal president of the United States. We would be loath to rely on may disclose. That would be our position in light of the importance of the information. And as to the Eastman case, really the point there is that case, which is of comparable complexity involving many of the same issues as this case, took the better part of 2023 with 3 or 4 delays, 3 or 4 breaks in the evidence. And I don't understand California very much myself. I wasn't counsel of record in that case, but I did follow it. I think even if we were to allow to pursue the relief I'm currently requesting, we would be standing in pretty good stead to get this case done much more expeditiously than the Eastern matter was. And Your Honor, Mr. Chairman referred to delays, and I'm not sure exactly which delay the chair is concerned about, but we would, I don't know if this was what the chair was alluding to, but we would resist, as we always have done, the characterizations from Officer of Disciplinary Counsel that we've ever played for delay, that was ever our strategy. The delays, we would not have requested them if there wasn't a reason for it, and the same is true here.
I understand that's your view, and
Mhm.
frankly, to me, doesn't matter. Okay. The fact is, the case has been delayed for a lot of reasons. Okay. You may think they were perfectly good reasons. You filed motions that did seek delay, and for a variety of reasons. And in some instances, those were granted. In some instances, various things played out. I'm not rehashing that, and I'm really not saying it's all your fault. It's, you're evil, they're good, they're vice versa. It's not that. Okay. It's that regardless, this case has been delayed pretty substantially already. And what I was alluding to wasn't that. Oh, it wasn't you're the blame for everything that's happened in the world. What I was alluding to is that for a variety of reasons that are not public, but you were aware of, the possibility is that a short delay results in arguments for additional delay.
I understand.
And that's a concern, right? That this is kind of our window for hearing the case is arguably true. Okay. And so that affects how, it'll just take 5 minutes to get an order from the DC Court of Appeals. And, I'm not so confident that happens instantaneously either. I mean, the court actually has other cases, but I just don't think I understand your concerns, but I don't think that's a reason to do that. And, Mr. Clark indicated that he was pleading the fifth long before we got to today. Okay. So I understood he was pleading the fifth in this proceeding, and he's entitled to do that. So I'm just not, I'm not struck that delaying the proceeding is the answer to this.
Thank you, Mr. Chairman. The final request, not rehashing anything, is it's maybe a little bit early, but given that we're on the precipice of perhaps resting our case, would this be an appropriate time for an afternoon break if the committee?
Yes, we can take an afternoon break.
Mhm.
Look, I do believe Mr. Clark wants to be heard. He's standing up in back of you. I do honestly, Mr. Clark, I do feel awkward about it because you're pleading the fifth, and I'm trying to avoid being the agent of you doing a waiver of a constitutional right by treating you as an advocate lawyer, making an argument and exploring the points you're making. I mean, it's a very awkward situation for me, and the easiest thing is to rely and you've got very competent lawyers, and if you rely on your lawyers, then you're not making any statement. I've never given anyone Miranda right warning, but it is kind of that sort of situation. If you start to talk about something, I don't know where it goes, and I don't know what you're opening up by talking. So it's.
May I speak to the court?
Mr. McDougall and I will be standing by to throw the flag if the flag needs to be thrown, if that's any comfort to the chair.
Okay, but that leads to some measure of discomfort for me. Okay. To get an argument that says X should happen because of Y. Well, what about Z? Well, now, no, you can't talk about that, right? Is really awkward from the standpoint of a lawyer stands up and a tribunal asks them a question. The lawyer has a responsibility now to the tribunal to respond to the questions of the tribunal. That's the tension you're creating by this situation. And I understand it, but I'm not going to prevent Mr. Clark from talking, but I am very concerned that there isn't really an easy stopping point to that. And as well as I do, the exact scope of waiver. That's why people assert Fifth Amendment privileges pretty broadly, that it isn't necessarily true that the exact answer to this question is going to make front page news at a criminal trial, But the concern is if you start talking about this, where does it go and what is the situation and how does it get applied? And I can't make those judgments. I don't know where this goes. I'm not even really intimately familiar with the criminal case, so I'm going completely blind, on that.
I understand the chair's concern.
All right,
Chair
Mr.
Hirsch,
Clark.
I could- So I'm not going to raise any issues about the facts. I'm not going to rehash any issues, Chair Hirsch. Thanks for the opportunity and thanks for your cautionary note. I'm just going to make two legal points to see if they turn you around on this. One is that comment 28 to rule 26, 1.6 indicates that I have a duty when issues like this arise to press appeals, that I can't just rest on an initial ruling. I have to take it all the way. And as you asked, would this entail Supreme Court review? Obviously, in full disclosure, it would. The second thing is you had referred to the fact that there is a provision in Rule 1.6 that refers to situations where if you're defending yourself in a list of proceedings, one of which is a disciplinary proceeding, then you have an exception. But the first subpoint on that is that that exception only applies to attorney-client privilege. And there are three other privileges that were invoked: executive privilege, law enforcement privilege, and deliberative process privilege. And respectfully, the rules that are established for professional conduct, they cannot override the law on those subjects as they've been either issued by courts or as they might trace as well potentially to statutes. For instance, FOIA recognizes deliberative process privilege, so it's not exclusively a common law issue. Either way you slice it, it's not something where those rules can override those privileges. So I think consistent with comment 28, we have the right to go forward on an appeal. And if we go forward with this proceeding and I cannot exercise my constitutional right to testify if I so choose, because obviously 4 of the privileges are not within my power to waive, only one of them because it's a personal right, the Fifth Amendment, I do have the power to waive, then I'm being denied my due process rights. You suggest that we could return and ask for the record to be reopened. But the problem with that is that potentially, depending on how things go forward, it could result in lots of prejudice to me. And I don't think any legal process should result in that kind of prejudice potentially without allowing an interlocutory appeal. So those are the points I would stand on. I don't think they work any waiver of the Fifth Amendment. And I don't think, Mr. Hirsch, that just to be clear, I'll make clear I am not intending to waive. I am making an argument that in order to satisfy my due process rights, first of all, the case shouldn't have been brought because inherently it requires invading these privileges, which need to go all the way potentially to the Supreme Court before they can be resolved. And so we need to take that interlocutory appeal. And I can't take the stand right now because I would be violating those privileges. And no lawyer should be put in that position, especially because these privileges are they're age old, they're centuries old, they're maybe as much as a millennia old because they go back to England and to the common law. And so it's the height of irony that disciplinary counsel, who's given a great public trust in order to protect these rules of ethics, that they are violating the rules of ethics. They're running roughshod over these principles, over these privileges that should be protected in order to try to hold me in violation of other ethics rules. We don't think that's proper. And for that reason, we would urge you to reconsider and to grant our ability to go seek an interlocutory appeal.
Okay, I've heard your argument, Mr. Clark. I just don't agree. And so I'm going to deny the motion. And why don't we take a break and you can indicate whether you're resting, and then if you're resting, I guess we can start closing arguments. Okay. Ready?
We are almost prepared to rest. I have one further piece of evidence I'd like to offer the court. It's a little bit untimely, but there's reasons for that. One of the witnesses on our witness list was Congressman Scott Perry. We, over the course of this trial, have been in discussions with his attorneys about his role and what it would look like. And where that all ended up is we just today, just a few minutes ago, received an extremely short affidavit from the congressman that we just now emailed to disciplinary counsel. I'll anticipate, we would like to offer it as our very final piece of evidence. I'll anticipate two objections. One being, I guess, hearsay, but there's already been plenty of hearsay testimony admitted by both sides, and this is an actual affidavit, so carries indicia of reliability beyond even hearsay declarants we've already heard from through our witnesses. Secondly, and perhaps more validly, timeliness. I've already proffered our reasons why we didn't have this earlier. And in terms of prejudice, just a simple glance at the affidavit, which I'm happy to share. It's only about 2 pages. It's not complicated, not technical. I would don't want to speak for opposing counsel, but it strikes me as the type of thing that could be easily, quickly processed and factored into closing arguments. So we would offer that as our final exhibit from our case and rest following the committee's decision on that. Thank you.
Mr. Fox?
Well, I have no opportunity to cross-examine Congressman Perry. I don't even know what the affidavit says at this point, but he is somebody I would very much like to have cross-examined because I think he could have shed some light on how the original contact between Mr. Clark and Mr. Trump came to be. And while I agree that hearsay can be admissible, I don't think hearsay where you have no opportunity to cross-examine the person who even heard him say it ought to be admitted. So I oppose it, and I say that without even knowing what's in there.
Well, it's kind of hard to address Mr. Burnham's prejudice point if you don't know what's in it in there. And it's a little hard for me to does anyone have a copy of what it is you're asking me to decide whether to admit? That might help.
Not a paper copy. I can email it in 30 seconds to Ms. Barraza, so I assume can forward it to the committee. I do not have a paper copy. We just got it over the break. That's the situation we were in. I regret it.
If somebody could email it to Ms. Barraza and if she could have copies be made and brought up, why don't we?
We still don't have it.
It's
No.
not attached to it.
I'm doing it right now.
Okay. And we can take another break to get copies. So we're actually knowing what we're doing. I'm very leery about admitting an objective and I have no idea what it is.
I understand.
So why don't we do that? It shouldn't take very long. Let's take 5 or 10 minutes.
Thank you.
Thanks.
Is there a place in the courthouse I could quickly print it out? I don't know if there's.
I can ask the board to print it out.
Okay, I understand.
Board office, print it out.
Yeah, if you email it to me, I'll have it printed.
Will do.
I'll be right back.
ask if we're not done at 5 on the dot, we'll be able to finish.
Well, I'm going to address that. I think I've changed my mind about doing argument today, but I'd rather do it on the record. All right, we're back on the record. All right, Mr. Fox, have you now received Representative Perry's declaration?
Yes.
Do you want to talk about it concretely then?
Sure. I mean, the substantive paragraphs are 4, 5, and 6. Paragraph 4 talks about something I don't even know anything about, hasn't been part of this hearing, HR1, whatever that is. But more importantly, paragraphs 5 and paragraph 6 have no substance. They just have opinions from this congressman. They say that these discussions in the fall of 2020, don't give us a date, were sincere. Nothing about the substance of what's said, just that they were sincere. And then the last one is just a paean to Mr. Clark saying that he behaved honorably, didn't engage in impropriety or unethical or immoral conduct without any meat on those bones. I don't think that kind of stuff ought to be admitted. I particularly don't think it ought to be admitted from a public official. Though, you know, public officials have a tendency to want to hide from confrontation and not be cross-examined. And this isn't like Congressman Gates, who got up here and testified and didn't have anything of substance to say, so we didn't cross-examine him. This gentleman has substance, but he doesn't have the courage to get on the witness stand and testify about it. And I think, and whatever you do in this case, sets some sort of precedent. And I don't think that the precedent to allow a congressman or any other public official to get away with this kind of conduct and submit an affidavit instead of coming in and testifying is something that ought to be rewarded. So I oppose the admission of this document.
All right. Mr. Fox, I want to compliment counsel in general. I admonished you before the hearing began not to try to get into personal attacks and various stuff. And in general, I think you've done an admirable job, you know, in doing that. I think both of you went a little bit overboard today. You know, I don't think we need to attack Representative Perry's courage or his integrity, you know, in any respect, particularly someone who served his country as a general. Okay?
I strongly disagree with you, sir.
All right, but I don't think we need to attack that. Okay, I don't think it's a matter of courage. I think it's a matter of how we decide our proceeding. You know, I take a lot of the points you make, Mr. Fox. I think the affidavit is of very little value, and I think Mr. Representative Perry is a material witness who, by doing it in this way, avoids cross-examination that could be relevant to this case. And he was not offered as a witness on the stand to testify about facts that are potentially relevant in this case. That said, I'll admit it for what it's worth. I'm not sure that it has a whole lot of value. I'll also add that I'm concerned that paragraph 6 exceeds the bounds of fair testimony because it's really his opinion about what's ethical and what's not ethical. And I'm not really sure that's appropriate testimony regardless. But, you know, I can review it and consider whether it affects all of us can review it and consider it. So I'm going to allow the affidavit to be admitted with all of those cautions about what, you know, effect it has, because I do think the inability to cross-examine him really matters in this instance. All right, with that, are you resting? No, there isn't. Do you want to give it an exhibit number? I know it's an affidavit, but so we can keep track of it.
In my email to opposing counsel on Ms. Perez, I just gave it the number of respondents, 3,000. It's not sequential, but I just wanted to get something I knew wouldn't conflict with anything else.
Well, at least it was 30 million. Okay, so our 3,000 will be admitted to subject to the limitations that I have laid out.
Thank you.
And with that, Mr. Chairman, we rest.
Okay. I think we may now have passed our window to have an effective closing argument today. In addition, it's late in the day, you're, shifting gears. I also thought we could take advantage of having a little bit of time now for me to try to give you some things to think about that might make the oral argument, the closing argument, more productive and useful for us. And I'm going to caution you, and I will do it tomorrow because people may be listening who didn't hear me today, but I think it's extremely important to understand. As I think counsel know in this, it's my approach, and I believe it is the approach of the remainder of the panel. We're asking questions. We're concerned about the answer. You can expect a hot bench. We have a lot of questions about this case. And one of the things that sometimes happens in cases is lawyers spend an awful lot of time talking about the things that they're comfortable with, that they have a lot of evidence to support or that aren't really contested. And then the hard questions end up on our lap, because neither party has effectively addressed the ones that most concern us. So what we want to do is focus the discussion on what matters for this. There are a lot of atmospherics in this case. Inevitably, it's not really the atmospherics. There are two charges that are made in this case. They're both attempts, so they come under 8.4a, which says that it is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through acts of another. And then that is tied with two other provisions of 8.4. So essentially there's an 8.4c claim that refers to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And there's an 8.4d count that refers to engage in conduct that seriously interferes with the administration of justice. So it's attempting to violate C and D that I understand to be at issue in this case. It's not a lot of other things that people discuss. That's what is the issue of this case, and it refers to Mr. Clark doing this, not other people. What I'm hoping that you will focus on is what facts are supposed to be either dishonest, fraudulent, deceitful, or misrepresentation. What is it that he is supposed to have attempted to do? Why that was an attempt under this rule? What he did that seriously interfered with the administration of justice, and deal with specifically how it is that we get from A to B, both affirmatively from disciplinary counsel's side and obviously attempting to negate it from Mr. Clark's side. I want you to focus on that. And if there are state of mind requirements that we're all aware of in connection with it, I want to know what evidence supports the state of mind determinations we're supposed to reach in connection with this, and identify specifics. I would like you to go through, if we're focusing on the proof of concept letter, I'd like you to go through there are two of them, any changes that there are between the two to the extent it might matter, and go through what it is you consider to be false in that, and what evidence you believe was adduced during this case that shows it was false, if that's, as I understand it, a part of this. So I'd like to go through that. There are questions that get raised about the situation and everything, and how the context affects it, how the Mr. Clark's status as an assistant attorney general and acting assistant general, and also briefly acting attorney general might affect this. I want you to be able to address this, how the context of government discussion affects these arguments, how the time frame that this took place affects these arguments. I want you to talk about the context and explain what facts support your respective sides in the case. The other thing, Mr. McDougall, I mentioned to you this paragraph that's been sticking in my head since the beginning of the case. I actually pulled it up so I had exactly what it was. And that you've quoted a lot from the first line of the paragraph, but there's additional stuff in it. The paragraph I'm referring to is on pages 2 and 3 of the Disciplinary Counsel's omnibus response to respondents' September 2, 2022 pleadings. Not the most charming name, but that's what it was called. It was originally filed under seal, but was subsequently unsealed. So it's a public document. And let me read the whole passage that I'm referring to, because I will, that's one of the hard questions that I want people to be able to address. That paragraph said, began is the wrong word. It was actually the middle of the paragraph to the end when my recollection of it being the beginning was incorrect. But the middle of the paragraph had the sentence, had respondent merely suggested sending the so-called, quote, proof of concept, close quote, letter to various Georgia officials, this case would not have been brought. It is generally not a disciplinary violation to make a stupid suggestion. Rather, these charges arise from respondent's conduct after he proposed sending the letter and was informed by his superiors that there was no factual basis for the claims made in it. Most significantly, that there was no evidence of fraud in the 2020 presidential election that might have affected the results in Georgia. I think it said 2 results in Georgia, but I think it's the is probably intended. The department lawyers who were familiar with the investigations into election fraud told respondent that there was no such evidence and attempted to put him in touch with the United States attorney who had conducted the Georgia investigation. Respondent did not follow up with the U.S. attorney. Nevertheless, he persisted in attempting to persuade and then coerce his superiors to send the letter asserting the false information, and when they still refused to do so, attempted to have himself appointed acting attorney general based on his assurances to the president that if he were so appointed, he would send the letter. Now, cases develop over time. That was a statement made a year and a half ago. So I'm not saying that's the metes and bounds of what the evidence ultimately proved. But at a minimum, we should start with, you need to respond to the rest of the paragraph and not just the full sentence. So I'm alerting you to that. There are a lot of other, questions we have. You can anticipate a hot bench, which is part of the reason why I didn't think we're going to get through an argument today. And I take your point, Mr. McDougall, that you'd like to go, not have one argument and then have it said, or interrupt in the middle is probably not ideal, But I'd like to focus this argument on what's going to matter, because we need to consider this. As I have explained before, our process is that after this argument, and, I anticipate we'll start at 9:30, we'll probably be late in the morning by the time it finishes. If an hour and a half wasn't enough, it's going to be 11:30 or something. We'll take a lunch break, and during the lunch break, we will talk among ourselves about the preliminary non-binding determination that I talked about. What we need to do as a panel, this is our job tomorrow after the argument, is make a preliminary non-binding determination that we think there's at least one violation that has been shown. If the answer is no, that's where we conclude tomorrow, although we'll have briefing. If the answer is yes, then there's a sanctions phase that would go into that. Recognizing preliminary non-binding is really the operative terms here. Determination is really a misnomer. That at that point, we're going to have briefing. The briefing is going to be on whether there's a violation, as well as if there's a violation, what's the appropriate sanction. We'll take what evidence. My understanding from Mr. Fox is he's not expecting to have evidence specifically concerning the argument, as opposed he's going to have argument, but not evidence concerning the nature of the sanction if we get to that proceeding. My understanding, Mr. McDougall, is you will want to call some witnesses in connection with it if we get to that proceeding, correct?
Correct. I have to do a little bit of planning on that, but so I would, if I could ask the chairman, would we proceed immediately to that phase?
Yes.
What, after lunch tomorrow?
Yeah.
Okay.
If we make the determination, then I'm expecting immediately to proceed to the phase. And I will also ask for your argument on sanction 2. At the end of having the whatever evidence you want to put in, I will take argument on assuming we do find a violation, what sanction would be appropriate. Then we'll set a briefing schedule. So in addition to being a preliminary non-binding statement from us as to what we're doing, the thing to understand is we then take briefing and we then review the record more carefully to make a real determination. And then even that is not a determination in the sense of a final determination, because what we issue is a report and a recommendation where we report on the evidence we found and make a recommendation to a board that makes a decision that then goes to the DC Court of Appeals. So we are a step in the process, and this is what we're considering as part of our step, but we're trying hard to do our best to do it as best we can. So
And I take it the briefing schedule will be set so that the transcripts are available to the parties.
Right. And the briefing schedule will be set I know that's a question that always leads to changes of color among court reporters. It does depend on, the ability to turn this into a transcript, and we don't.
I tried a case last August and we still don't have the transcript and haven't had the new trial
Yeah.
hearing. So
I mean, it has not generally taken that long. Ms. Smith, do you have an estimate on what it would take for a transcript, just so we can keep that in mind?
They're delivered 10 days from the 10 business days from the date of
The date of,
proceeding day.
oh, okay. So the 10 days is already running with respect to the earlier days of the proceeding. Okay. So it sounds like you'll get them gradually over time, with the last 10 days after tomorrow, if we finish tomorrow.